On Amicus briefs today as promised. It apparently became a bit of a heated discussion last week, and there's good reason for that. In fact, Amicus briefs have been at the heart of quite a few heated discussions these days because of the way in which they've morphed through time in purpose and application. We, the people of this century, can't have nice things. Well, because we kind of ruin everything. And the Amicus brief is just one of those things. As Bryan Freedman pointed out in his letter, there are not standards listed for amicus briefs in the federal law code for the district court level. Why? Because they didn't really used to be part of district court cases. Civil cases in district courts are basic litigation. Appellate courts, and especially the Supreme Court, go way beyond litigation. They deal with things like appeals, and in the Supreme Courts, let's say, for example, something is not going right in regular litigation. I'm not talking about a small thing, maybe a problem with the judge, something that's referred to as extraordinary. Attorneys may go above the judge and file a writ, say a writ of mandamus, for example, with the state Supreme Court to ask them to intervene and rule on the issue at hand. Now, as I said, it takes something extraordinary for the state Supreme Court to accept it. But this situation and an appellate court, these situations go beyond basic litigation and into broad legal principles. They deal with interpretation of the law. They deal with how the initial trial was conducted, looking for errors, things like that. So in these courts, we can understand the purpose of an amicus brief. In most cases during basic litigation, though, the attorneys should be well enough versed in law that they don't require the help of a friend of the court. So it was never really set up that way. But if you just Google amicus briefs in federal court, if you're not aware that it's not part of the law code, when the appellate court rules pop up, you might assume that they're part of that law code. Even though these are usually seen more in Supreme Court and appellate courts, they have begun to creep into district courts more often. And of course, that's what we found ourselves involved in the Blake Lively case. My personal opinion, this is a Blake Lively problem. She filed a motion to dismiss. It hasn't been granted yet. And we know how she gets when she's waiting for a reply for something she wants. Remember those walls of text she would send Justin when she wanted him to accept her writing of the rooftop scene? The writing that may or may not have been Ryan's writing? I bet Ezra is getting quite a few walls of text right now. I hope she's charging Blake to have to read all of that. And who knows, knowing Blake, she's probably tried sending them to Judge Liman, telling him about her dragons. I can just see her being pushy enough to ask for his phone number so that she could do that. So, the motions to dismiss haven't been granted. She filed for sanctions. But that hasn't been decided yet either. And you know right now, they're trying to schedule her deposition. The deposition that one of the first things she said at the very beginning of this lawsuit is that she didn't want Bryan Freedman to depose her. Imagine thinking that you could just declare this in court and somehow get out of your deposition. But that's Blake. She's probably pretty desperate to get this case dismissed before she has to do that. And she's probably been driving Ezra crazy till Ezra came up with this amicus idea. Also in this episode, we're going to see how Ezra ties directly to this amicus brief as well. But we're mainly going to focus on why amicus briefs are considered controversial. They've been around a very long time. They're a gift from the days of Roman law. On May 29th, Bryan Freedman filed a letter in opposition to these amicus briefs. I kind of wish this letter had been written in stronger language. I understand why it's not. Bryan's been criticized and slapped down far too much by Judge Liman, in my opinion. I imagine he's trying to not stay on the judge's bad side, but this situation with these briefs actually has the potential to alter this whole case, and it falls squarely on the shoulders of Judge Liman at this point. I can't say I like that. We haven't really been able to see much of Judge Liman at this point to be able to form a solid opinion of him, so it's very hard to see where he stands on things. His background does make him familiar with amicus briefs. I don't know if this familiarity will make him more likely to accept them, or if it will help him see that these are frivolous. And you'll understand why that's important as we get through this episode. So Judge Liman has a pretty amazing education. He started off at Harvard. Then he moved to Yale for his law school. As if that's not impressive enough, in between, he attended the London School of Economics. After graduating law school, he spent a year at the NAACP Legal Defense and Educational Fund. He then clerked for Judge Laval on the U.S. Court of Appeals for the Second Circuit, and then for Justice John Paul Stevens on the U.S. Supreme Court. Quite impressive. Now, as I said at the beginning of this episode, these two types of courts specifically are where we see the majority of amicus briefs filed, especially the Supreme Court. But I also want you to keep his experience in mind for later as we expand on that. Freedman begins his letter by mentioning timeliness, and I've color-coded these by topic. We're going to concentrate first on these yellow highlighted parts. Timeliness is important because it is one of the big determining factors of the acceptance of these briefs in both the appellate courts and the Supreme Court. It's a very rigid standard. I have several reference articles that I'm going to share with you today, and we're going to start with a letter of proposal written to the Secretary on the Committee on Rules of Practice and Procedure, Administrative Office of the United States Courts. This was filed by attorney Akiva Shapiro of the Gibson, Dunn & Crutcher law firm. This is a very important law firm. In a list of the top 100 law firms in the world, not just in the United States, it ranks as number 10. It's a huge international law firm with 21 offices around the world. They have over 2,000 attorneys. They began in 1890, so this year they have 135 years of experience. They have so many different districts that they operate in, so they really have experience knowing what kind of standards should be set to create a uniform code. They no doubt face a lot of differing opinions depending on where they submit these briefs to. So they propose that the district courts amend their laws to include rules in dealing with amicus briefs. They say that guidance on how and when to file them in a federal trial court is scarce and haphazard. No uniform federal rule exists, and that some district courts have adopted local rules on the issue, most have not, leaving the situation where, as they say, parties are generally left to consider a hodgepodge of often unwritten local practices and guidance that vary by the district, and even within the same district, they can vary by the individual district judges. They've searched for rules that govern the circumstances to accept or refuse them, how they should be formatted, when and how to file. But all they've been able to find is sparse, common law style authority, and that we do so at the expense of uniformity and predictability across cases, judges, and geographic locations. Parties in counsel without prior experience in this area are forced to muddle through without fixed guideposts. It goes on to cite cases that mention this, where they say pretty much the same thing, that no statute or rule exists, that resolution lies in the firm discretion of the district court, and that the district courts have thus adopted inconsistent standards regarding when they should be accepted. So in this proposal, one of the big things they address is timeliness and what they think should be taken into consideration. As far as timing, they say that a federal rule should ensure that they're required to file in a timely manner, and this is a big point. The reason is so that it doesn't prejudice the existing parties by unduly delaying the pending matter. Also, another big part of timing would be giving the parties the opportunity to respond to the brief in advance of the motion, hearing, or trial. And so this means that it should typically be filed after the party the amicus is supporting files its principal brief, but sufficiently in advance of the opposing party's responsive brief. So as you've been watching this case, you saw that there's a time limit that each motion needs to be filed by. Then there's also a deadline for the response to that filing. So what they're saying is that the amicus should come after the initial filing, but sufficiently in advance of the brief, because if it's going to be considered, it should be able to be included in the brief. If it's handed in the day before or on the same day as the deadline of the response, it won't be able to be included. So this timing is very important. What it provides the courts with then is a clear basis to deny late filed briefs that would cause this situation of prejudice or delay proceedings, and that such a rule will therefore better preserve the court's ability to manage their docket and to efficiently resolve motions. Now, with this proposal, they include 3 exhibits as examples for how to create a standard at the district court level. We're going to start with the appellate procedure. This is the one that steered a few people wrong last week. In these rules, Not only is there a standard of timeliness, but it's subdivided according to the different types of filings. So each type will have its own rules. So for example, an amicus brief that's filed during the initial consideration of a case on the merits, the United States or its officer or agency can file without the consent or leave of court. Anyone else must file by leave of court, or if the brief states that all parties have consented to its filing. So here, besides timeliness, we need consent, either consent of both parties or consent of the court. Now, for the sake of time, we won't be discussing all the different types and how they differ, but you can see how clearly these rules are laid out. Another part of the rules of the appellate court are length. The amicus brief can be no more than 1/2 the maximum length authorized by the rules for the party's principal brief. And we've seen situations where the parties ask the court for leave to file a longer brief. If that situation comes up, and the court does grant a longer brief, that extension does not apply to the amicus. It must stay within the maximum length in the rules. And now we see the standard rules in the appellate court, the time. So the proposal was between the filing of the initial and the reply. So the actual rules in the appellate court are exactly that. No later than 7 days after the principal brief of the party being supported is filed. And then there's another rule. If you're talking about a brief that does not support either party, they must file their brief no later than 7 days after the appellant or petitioner's principal brief is filed. But back to this idea about the length of it, these briefs that were filed, I felt like they were kind of outrageously long. We have a busy federal judge here. He's already buried in motions to dismiss that he hasn't decided yet. We have so many parties to this lawsuit. And then they buried him in these long, wordy, repetitious amicus briefs. I hope it aggravated him. I really do. He should be aggravated. Now we have even more specific rules, the rules of the Supreme Court of the United States. They have a whole chart. In this chart, they list even more different types of amicus briefs. For each one, they list the rule or rules, the word limits, and the color of the cover of the amicus brief. We're not going to go through all of these, but I've highlighted the rule in green, the different types of these briefs, and some of the main points about them. And if that's not specific enough, it gets even more specific. When these briefs are submitted, they have to be accompanied by a certificate that's signed by the attorney, the unrepresented party, or the preparer of the document stating that the brief complies with those word limitations. It has to state the number of words in the document. It even gives instructions on whether or not you can use a word processing system to count the words. The words have to include footnotes. If the certificate is not signed by a member of the bar of the court, the counsel of record, or the unrepresented party, it must contain a notarized affidavit or declaration that it is in compliance with 28 U.S.C. Section 1746. Not only that, it has to be 8.5 by 11 inch or letter size paper. It shall appear double-spaced, except for indented quotations, which shall be single-spaced, on opaque, unglazed, white paper. It has to be stapled or bound at the upper left-hand corner. If you also submit copies, those copies have to be produced on the same type of paper, and they must be legible. And this isn't all. It goes on with 3 more pages devoted to the rules for these different kinds of briefs. It's a lot. For the sake of time, we're moving on. We don't need to know all of that. But what I like is that Judge Liman began his career first as a clerk for an appellate court and then the U.S. Supreme Court. So his introduction to amicus briefs is related to these standards that we just looked at. So I hope, again, that this gives him some disdain for ones that are not filed under very specific standards. Specifically, them filing these briefs now, at this stage of the game, and expressly mentioning these briefs helping them with the motions to dismiss, which, if applied to that, would definitely be disruptive to Judge Liman's schedule, and we know federal judges do not like their schedules to be disrupted. They're super busy. They have huge workloads. If one case gets messed up, it could have a domino effect on his entire schedule. They don't like that. And we're going to expand on all the ways that accepting it could affect that. The final example they include is for DC. So DC has actually set standards for these briefs in their district court. They're pretty basic, they're not as detailed as the appellate and the Supreme Court, and they don't give the time limit, that 7-day limit we saw. They leave that part up to the individual court. And this, I felt like, was an important point. Why their position is not adequately represented by a party. Why the matters they're asserting are relevant to the disposition of the case. They have to state their position, and they must be accompanied by a proposed order. It should be filed in a timely manner. It doesn't give the exact time, but it does say that it does not unduly delay the court's ability to rule on any pending matter. It also states that any party may file an opposition to a motion for leave to file an amicus brief, concisely stating the reasons for such opposition within 14 days after the service of the motion or as ordered by the court. Now, we saw that Freedman put it in within 2 days because that's a standard somewhere else, and he was afraid if he turned it in any later than that, it would be considered untimely. That's unfortunate for him because 2 days is not very long. If there was a rule that said something like this, that he had 14 days, that would have been better. He could have had more time to do more research and write up maybe a better brief, but he didn't know how long it could be, when to file it, none of that because these laws just do not exist. So that's how they do it in DC. Another good article, and I'm putting all of my sources on here, first of all to show you that this doesn't come from me, but from these different source materials. And also, if you're anything like me, and you love deep diving into stuff, I put all my favorites on here so that you could go and look them up for yourselves and maybe read the whole thing. This one's pretty short. This is just a little article in the New York Law Journal. It's interesting though, this was written by Akiva Shapiro, the same person who wrote the letter proposing that the district court adopt rules of their own on these briefs. But this had some really good ideas, a little bit of background about amicus briefs, but also good ideas, since there are no rules, for attorneys to turn to write better amicus briefs for the district court level. And the whole point was to make it more palatable to the judge who has to hear them. One of the important things it mentioned was the timing. It says it's also crucial that an amicus brief is filed in time to give all parties the opportunity to respond to the brief, ensuring the amicus brief is filed in a procedurally fair way. It's crucial to be fair to all parties. So for example, these briefs they just filed, as I said, they want them to be considered with the motions to dismiss, because they erroneously applied 47.1 to mean that the plaintiff should be able to get the defamation suit against them dismissed during this stage. If that's what they were going for, the ideal time would have been after Blake, Ryan, Leslie, and Stephanie filed their motions to dismiss and before the response was due from opposing counsel. And if they missed that, well, guess what? We had a little bit of back and forth, didn't we? The same plaintiffs turned around and filed in opposition to their motion to dismiss. So they had a second chance to get it in during the time between that filing and opposing counsel responding. They missed that. Now, we're way past the motions to dismiss. And now they want to submit something that's supposed to be taken into consideration with the motions to dismiss and doesn't give opposing counsel a chance to respond? That's crazy. Now going back to this proposal, it mentions this point too, that the motion for leave shall be filed in a timely manner so that it does not unduly prejudice any party or delay the court's ability to rule on any impending matter. Now in this it points out the reason, the word prejudice. So if opposing counsel has already had their say, everybody had their fair shot, now you get these people to come in completely on Blake's side, and it's like they get another chance at filing a 25-page motion to dismiss. And the other side doesn't get that. It's highly prejudicial. They suggest saying, in no circumstances shall a brief be less than 7 days before the filing deadline for the final brief of the party not being supported. And not only are we past that, we're past it all. And that it should be no more than 1/2 the maximum length authorized by these rules or any superseding local rules. In that one in the New York Law Journal, it suggested combining the letter for leave with the actual brief in a maximum of 8 to 10 pages, specifically so you don't upset the judge, who's already buried in decisions and paperwork. And now we're getting back to Freedman's letter. One of the other things that he mentioned in yellow, and he has this bit in quotes because he's making a point. He says it was filed, and here's the part in quotes, with Lively's consent. Keep that in mind because that's important too. And what he's pointing to is in this letter for leave to file the brief, after identifying all the different associations, it says defendant Lively consents to the filing of the brief. He's pointing this out to the court in case the judge misses this point. This is something, again, Blake has been aware of. She knew this was happening. Opposing counsel didn't. How long did she know this was coming? We don't know at this point. Did they cook this all up together? Probably. As I mentioned, we're going to get to a connection between Ezra and one of these organizations, but he's pointing this out. And unfortunately, he's not been treated too well by this court. He's trying to be very subdued, I feel like. I think in the past, he would have had some biting remarks here about it. So I feel like he's staying way below the clouds here, but still pointing out something very important. Yet another thing that Blake has been involved with her law team behind opposing counsel's back. Now let's look at these green parts. His second point is the publicity angle. Now, if I were preparing a brief like this, and again, they had so little time because they were worried about it being in too late because there's no standard. But I would have put links to the articles that came out about these organizations supporting Blake. I would have put those in the footnote just to make this point because we don't know if Judge Liman saw that or not. And to me, this goes along with him pointing out Blake's consent. Blake's not your average plaintiff. Not only does Blake have a million lawyers, she has lawyers with these kinds of connections. She has these allegedly devious lawyers to do things like sham lawsuits, for example. But she's got a full-blown PR team. So when she made this move, she had Ezra, that has a connection to one of these organizations, at least one of them, to help get the briefs in the first place. Then she has a whole PR team to tell the world that these organizations support Blake. So rather than just saying this is a publicity stunt, I definitely would have put links, clickable links, in the footnotes to these articles that were announcing this to the world, that these organizations support Blake in this lawsuit. Because that's a big deal. And see, if they don't get chastised by Judge Liman for this, after all of the chastising that Freedman's gotten for playing up to the press, I'm going to be really, really irked. Because this was a publicity stunt. But the wording and some of the bold claims that are in these briefs that are not in harmony with things like 47.1 that got released to the public, got a lot of people talking and got them talking incorrectly. It's definitely a PR stunt in my opinion. And next we have the purple statement. It says that their brief fails to aid the court in its task at the pleading stage. So he's like, this isn't even the right time for this. And he's saying it doesn't aid the court. So let's focus in on that for a moment. The purpose of an amicus brief, friend of the court, remember that's what it means, is that it's supposed to help the court. They claim that's what they're doing, but as they ramble on in these briefs, their focus becomes crystal clear. They have inserted themselves to further their own interests at seeing this 47.1 put to use. Now they keep referring to it as it was named in the bill stage, the 933. That's when they were trying to get it passed. I don't know why they keep calling it that, because it's been passed now for over a year, and it's called 47.1 now. But their language gets more and more desperate, and they resort to, in my opinion, some very low tactics, and we'll develop this as we go on. But my next source is the North Dakota Law Review, and this one's kind of long, but I highly recommend you looking this one up if you want to do further research. So it's the North Dakota Law Review, and this article deals with the ways in which amicus briefs are problematic. Now it focuses beyond just domestic briefs. It also mentions the problem of foreign submissions. But the information that's in this is really good, whether it be domestic or foreign. And it's really good for this particular lawsuit, I feel. It mentions a couple of expressions here, and these are terms that some opponents of these briefs have begun to refer to them as, due to these negative experiences in the different courts. So instead of friend of the court, they've been referred to as litigating amici. Some say amici. I prefer amici. It's more like the actual Latin word. That's how you say the word friends in Italian, by the way, and Italy is one of my favorite places to visit, so you're probably going to hear me pronounce it that way most of the time. But litigating amici, and none of these terms we're about to hear are meant as a compliment, by the way. It means that they're supposed to be a friend of the court, helping the court, but instead, they're actually litigating the case. It means they're overstepping. So instead of amicus curiae, it's litigating amici, litigating friends, because the ones filing are referred to as amici. The next one it mentions doesn't need an explanation. They just straight up call them legal mutants. So it's a mutation of something. It's not supposed to be what it is. It mutated into something that it shouldn't be. And then we have amici petitor, which means friend of the plaintiff instead of friend of the court. It means that they're just too obviously there to advocate for the plaintiff. And I think we definitely have this sense with these briefs. They are exclusively here for Blake. They are not a friend of the court. They are a friend of the plaintiff. Now, they're also talking about the rules, and they say that a lot of people have proposed making these rules for the federal rules of civil procedure, and they focused on a lot of things, but one of the things that they've not focused on enough is to the party's response to factual allegations in amicus briefs. The brief shouldn't be making factual allegations about the case, but I feel like these briefs do. They talk like Justin's already been found guilty, like it's already been proven, like he's already gotten a verdict. There's a lot of problematic language in these briefs, in my opinion. And so if that's the situation, it asks the question, how can a party prevent an amicus from alleging facts or submitting documents with its briefs? Can a party obtain document discovery from the amicus to disprove its allegations? And it says there are methods to oppose and to obtain discovery. So if you're going to put these factual allegations out there, opposing party can obtain discovery from you. If you're going to litigate, let's go all the way. If you're going to pretend you're counsel, you should have to submit discovery like the other counsel does. And they state, allowing them to allege facts and provide prejudicial documents to opposing counsel without opening themselves up to discovery leads to parties being unable to fairly present their side of the dispute. So if you're going to overstep, opposing counsel should be able to step back. Next, it talks about historically what amici were responsible for. They were there to bring up cases not known to the judges. Also, they would challenge certain proceedings as fraudulent, or challenge things like collusions between plaintiffs and defendants to foreclose rights of third parties. Today, however, and this is why I said in our time period, we ruin everything, because it says today they appear as advocates in favor of one party or another, with influential parties lobbying the court. And that's what they're doing. They're in there lobbying the judge. Now it points to Judge Richard Posner. He is a legal scholar who wrote around 40 books on a variety of legal subjects. He's referred to as the most quoted judge, not just of his lifetime, but of all time. He served on the U.S. Court of Appeals in the Seventh Circuit from 1981 to 2017. He had a lot to say about amicus briefs, because he handled his fair share of them. This is one of the cases that he presided over back in 1997. This was a situation of John H. Ryan versus Commodity Futures Trading Commission. Now, Ryan had done something, and he was being punished by the Commodity Futures Trading Commission. The Chicago Board of Trade moved for leave to file an amicus brief to support him as he challenged this disciplinary order. So he receives this motion for leave to file, and he denies it without a statement of reasons. He's like, not today. No. And so the Board of Trade files a further motion. They're like, explain yourself. You didn't tell us why. You just said no. And he says, which I am happy to do. And when you hear those words, you know something's coming. And boy, does it. He says, the tendency of many judges of this court, including myself, has been to grant motions for leave to file amicus curiae briefs without careful consideration of the reasons why a brief of an amicus curiae is desirable, although the rule makes this a required part of the motion. So he's saying, we're supposed to do this, and we don't. Even me. After 16 years of reading amicus curiae briefs, the vast majority of which have not assisted the judges, I have decided that it would be good to scrutinize these motions in a more careful, indeed a fish-eyed fashion. So he's like, you know what, 16 years of this, I'm not doing this anymore. You're not just going to get past me anymore. You're going to have to prove yourself to me. He's kind of had it. He says, the vast majority of amicus curiae briefs are filed by allies of litigants and duplicate the arguments made in the litigants' briefs, in effect merely extending the length of the litigants' brief. So do you see what he's saying? Like we just talked about, the motions that get filed in court all have limits. Limits in length, limits to how many of them that you can file. But these briefs, they just give you a freebie. A whole new filing that opposing counsel doesn't get. And like he said, they repeat a lot of the same stuff. He says, such amicus briefs should not be allowed. They are an abuse. The terms amicus curiae means friend of the court, not friend of the party. We are beyond the original meaning now. An adversary role of an amicus curiae has become accepted. So, do you see what he's saying again? He's like, these are not what they're for, but it's become accepted now. It's an adversary role, not a friend of the court. It's an extension of the plaintiff now. He said it shouldn't be allowed. An amicus brief should normally be allowed when a party is not represented competently or is not represented at all. When the amicus has an interest in some other case that may be affected by the decision in the present case, and this is important, though not enough affected to entitle the amicus to intervene and become a party in the present case. Or when the amicus has unique information or perspective that can help the court beyond the help that the lawyers for the parties are able to provide. We're going to focus on that section in a moment. Otherwise, leave to file an amicus curiae brief should be denied. So if it doesn't meet the standard, it should just be denied. The Chicago Board of Trade's amicus brief falls into the forbidden category. The petitioner argues that he should not have been punished because he has been rehabilitated, as shown by the Board of Trade's decision to reinstate him. The amicus brief echoes this argument, saying in effect, yes, indeed, he has been rehabilitated, for otherwise we wouldn't have reinstated him. The petitioner argues that he poses no threat to the public so long as he is constrained to operate under the supervision of the Board of Trade, and the board echoes this argument too. As long as he's under our supervision, the public is safe. The petitioner's brief is 45 pages long. The board's brief, if allowed to be submitted, would in effect bring that length up to 62 pages. The board claims to have an overriding interest in the case because one of its members is being punished unjustly in its view, and to be able to assist the court by expressing its strongly held view that the evidence clearly and convincingly establishes the lack of any need for the sanction meted out by the commission. We are not helped by an amicus curiae's expression of a strongly held view about the weight of the evidence, see New England Patriots Football Club, and then it cites this case, but by being pointed to considerations germane to our decision of the appeal that the parties for one reason or another have not brought to our attention. The amicus briefs filed in this court rarely do that. And this amicus brief is not one of the rare exceptions. Where there's some doubt about the Board of Trade's position concerning the sanctioning of Mr. Ryan, an amicus curiae brief might serve to inform us of a material consideration of which we might otherwise be unaware. There is no doubt. The board pronounced him rehabilitated and reinstated him, and the commission, disagreeing with the board's evaluation of Ryan's danger to the investing public, went ahead and sanctioned him anyway. The amicus brief does not tell us anything we don't know already. It adds nothing to the already amply proportioned brief of the petitioner. The bane of lawyers is prolixity and duplication, and for obvious reasons is especially marked in commercial cases with large monetary stakes. In an era of heavy judicial caseloads and public impatience with the delays and expensive litigation, we judges should be assiduous to bar the gates to amicus curiae briefs that fail to present convincing reasons why the parties' briefs do not give us all the help we need for deciding the appeal. The motion for clarification is granted, and the denial of the motion for leave to file a brief amicus curiae is reaffirmed. Now, comparing Blake's to what he's saying here, amicus briefs can give a whole new filing. So she's filed all of her motions to dismiss that she can file. She added a motion for sanctions, and now she's throwing this in. It's like she keeps being able to file new motions to dismiss. Oh, that didn't work. Well, here's another one. Oh, that didn't work. Well, here's this. She's impatient. And when you're a spoiled brat who's used to getting what you want when you want it, you find new ways. Just like the sham lawsuit and getting the contents of Jennifer Abel's phone. Even though it looks like it's quite possible that those methods were actual federal and state crimes. She nor her attorneys seem to care too much about following any kind of rule. And now back to this point about allies of the litigants. I watched Kirsty Fla this morning on Flossom Talk. She reported that one of her subs by the name of Angela, shout out to Angela, found something. Well, let's hear her tell us.
Anyways, Angela found out that Ezra Hudson, who is representing Blake Lively, one of Blake Lively's lawyers, one of the ones that have been mostly out in the press, she is on the board of that organization. I mean, you can't make this stuff up. She also says in the email to me, another one of them was California Employment Lawyers Association. Ezra is likely a member as she's head of managed employment and labor practices. She says here this probably has no legal ramifications like it would if there was a connection between these nonprofits and Blake. However, the connection to Ezra looks bad and means there was likely a prompt from Ezra for them to be filed. For sure. This just makes everything look so terrible. I just don't understand these lawyers who represent celebrities or big clients like this that are willing to go so far because it makes them look bad as people as well. I know it's their job to defend someone or to speak for someone else, but I don't know how some of these attorneys sleep at night because this is hurting other real victims, what they're doing here.
So, this is no surprise at all, is it? We expected news like this. I just hadn't had time to dig into it myself because I was doing all this digging. But this is the inspiration for this episode's thumbnail. And I've kind of repeated it a couple times already. Blake does not want to be deposed. This came out at the very beginning when she thought she could just tell the court, oh, I don't want to be deposed by scary Bryan Freedman. Tried to say, I'm a victim and he's so mean to victims. She thought that would make having to take this deposition magically disappear. She was wrong. And then, as I've said a couple times already, the motions to dismiss, the sanctions, now this. And her attorneys have helped her do all of these things. She wants out of this lawsuit that she started. And that's what this is all about, in my opinion. She wants dismissed before she has to be deposed. And she's using all of these organizations to litigate for her or to force the court to let her out of this lawsuit. And these law firms are using all of their connections and all of their underhanded ways to try to achieve this. One of the most famous quotes that you'll see about Amicus briefs, and you'll see it in probably every writing about it, was found in this, and I told you we were going to cover it more. So these standards of when an amicus brief should be allowed are 1, when a party is not represented competently, 2, not represented at all, representing themselves, pro se, 3, when the amicus has an interest in some other case that may be affected by the decision in the present case. There is a caveat to that, though. Not enough to entitle the amicus to intervene and become a party in the present case. And later we'll see that applied with the word excessive attached to it. This is by far the most important standard when discussing briefs, this right here. We have some of the best and brightest attorneys working this case. That's undeniable. I don't care for Ezra, but she does have a high ranking. Michael Gottlieb's firm is number 46 in the top 100 law firms in the world. Are we really supposed to believe that these attorneys need help? That they're not representing Blake competently? They're not fit to represent their clients without these amici? And why do they need the help from these organizations? They've got a member of the board on their legal team. They're already represented. It talks about them not becoming a party in the case. They've already petitioned and been granted pro hoc vice status. They're officially on the docket now. And they are fighting exclusively on Blake's side. And it's all about this 47.1. This seems completely an opposite of Judge Posner's statement. And as I said, the mention of this interest in the case, that's going to come up later too. So keep that in mind. But Judge Posner, the most quoted judge of all time, clearly says if it doesn't fit this standard right here, it should be denied. And I love the way he ended this, just like a boss. He's like, yeah, I'll grant you an explanation. Here's my explanation. And guess what? Chicken butt. No, guess what? Still denied. Now let's go back to this North Dakota law review. It talks about potential interlopers who allege policy reasons for or against the party's positions. So what can a party do when an amicus begins to allege harmful facts? And I believe these do. A party would want to subpoena documents from the amicus to disprove the allegations. That's going to take some time. The judge isn't going to like that, but it's only fair. If he lets this in, he should have to let this play out. Now, it goes on to say in this particular article, Part 1 explains how the machine has been used and abused to influence the courts beyond the filing of briefs, and that because of this absence of rules governing the participation, the courts have discretion to grant amici a variety of functions, enabling some of them to actively participate in discovery and even trials, and that's alarming. This is what happens when there's no law. So the methods that could be deployed, the one thing that Bryan Freedman already did, he filed an opposition, and then it keeps mentioning obtaining discovery. And then Part 3 explains how allowing foreign amici, but I think this applies to domestic as well, to allege facts but avoid discovery can create serious injustice. So if Judge Liman accepts it but doesn't allow discovery, which he very well could because there's no rules, it would be a serious injustice. Now, looking back at Freedman's letter, we're crossing into the blue statements on this letter as well, that if these get accepted, they can be challenged. So if we follow this process through, if somehow these briefs do lead to the granting of a motion to dismiss, if this motion to dismiss is given without prejudice, it could start the whole process over again. Because if it's given without prejudice, leave should be given to file an amended complaint. We saw how long that all took. Once one side amends, the other side has to file answers, interrogatories all over again. They will also file motions to dismiss again. It's resetting everything. Now, if he grants it with prejudice, they can appeal, and I believe they will appeal. So it can get wildly out of hand very easily, very quickly. But even if he doesn't grant the motion to dismiss, if he accepts it, the rules allow, in other places, not the district court, but they allow the opposition of these briefs and even the obtaining of discovery. This would cause delays as well. It can get out of hand really fast, is what I'm trying to say, because it would really, really be unfair to accept them and not allow them to be questioned. Because why shouldn't they be questioned? Wayfarer already has to fight all of these attorneys. As I said, Wilkie Farr & Gallagher, number 46 on the top 100 firms in the world. In addition to all of the other counsel from these other big firms, they have to fight an ex-CIA agent who's out there doing who knows what. They already have to fight this sham lawsuit and this sham subpoena. They have to fight these two egomaniacal celebrities, in my opinion. They have to fight Marvel and Disney. And now, all of these organizations, the ERA, the California Employment Lawyers Association, the California Women's Law Center, we saw Ezra's role there. They gotta fight all that? And these organizations should just get to drop these huge briefs and go unchecked while they demand motions to dismiss to avoid discovery? It would be insanity. It would be so unfair. I really hope Judge Liman gets this right. Continuing on in this North Dakota law review, they list examples of when these briefs got out of hand. So we have a situation with the Equal Employment Opportunity Commission suing Boeing. So in addition to covering things like sexual harassment, if you remember, it's all employment and labor discrepancies like that against not just women, but it includes, in this case, ageism. So Boeing wanted to make the forced retirement age of pilots be the age of 60, and the EEOC was fighting this. Now, 16 former Boeing pilots intervened in this. They wanted to get involved as amici, and the court allows it. Now, anyone that's not familiar with the airline industry cannot fully appreciate the amount of power that pilots have, because they can shut the world down by going on strike. So the court gives them this outrageous power. They require the EEOC has to consult with the pilots before they can finalize a settlement. So they can't settle without consulting, not notifying, consulting these pilots. Not only that, they allow them to access all the pleadings. They can appear at all the depositions, not just to sit there and watch. Imagine 16 pilots sitting there in a room that's already full of all the people involved in a deposition. They're not just there watching, though. They're allowed to depose the witnesses. They can file their own briefs on any issue. They can argue the deficiency of any settlement, and they even get to participate at trial. Now, I don't know what they promised this judge to get this, but I shouldn't say that. I mean that as a joke. I'm not saying this judge was bought, but it's outrageous. He basically turned it into a class action lawsuit without it being a class action lawsuit. Now, when you hear of one thing like this, what happens? It starts happening everywhere. If so-and-so did it, why? The scope of Amicus participation in district court expanded so drastically that eventually it encountered opposition from some courts of appeals. Because you can imagine these briefs come along, there's all of this interference by people who aren't even a part of the lawsuit. When the defendants lose and they appeal, now it's the Court of Appeals problem. Now they got to untangle this mess. And what are they going to do? Invite all of these people, these amici, into their appeal? They're not going to do it. They know the rules. They have very clear rules. It can't even happen in the Court of Appeals like this. So they're left to sort through this mess, and they get sick of it. But as this became a problem, we see the Sixth Circuit just had it. So when they were considering the appeal for United States versus Michigan, they didn't just call them litigating amicus. They said legal mutant. They say it seriously impinges the inherent rights of the only real parties in the litigation and lacks any basis in law. They accused the amici in this Michigan case of fermenting much of the discord, bitter confrontation, and continuing acrimony that has pervaded the proceedings. It says these scathing remarks have been credited with stifling the growth of the litigating amicus practice, with commentators claiming that the litigating amicus is an idea of the past. But it states that it has not disappeared from the courts. Like Frankenstein's monster, it still appears in the fringes of our case law, and that the United States continues to appear as litigating amicus curiae in what? Certain civil rights actions. And this is exactly what we're dealing with Blake's case. We have these civil rights organizations coming and wanting to appear as litigating amici. As it says, amici thus continue to participate in litigation as more than lobbyists or policy advocates and can assist parties with developing a record that is favorable to the amicus's position. And there's a footnote to this about this becoming an idea of the past. This is another source I used today that I would recommend if you want to do further research. This is a good one for it. It's called Frenemies of the Court, which is brilliant to me. They're not friends of the court anymore. They're frenemies. They're making so much trouble for the judges and for the later courts of appeals. The many faces of the amicus curiae. And in there, it cites this Michigan case, reminding that amici may not participate as litigating amici. It is not a party and has no control over the litigation and no right to institute any proceedings in it, nor can it file any pleadings or motions in the case. So the Sixth Circuit Court of Appeals attempted to establish limits, but did it really in this situation? And the thing about these civil rights actions, like what we're seeing in Blake's case, no one wants to appear to be on the wrong side of civil rights. Civil rights causes are usually things that most of us see as the correct thing to do. For example, the civil rights throughout the 60s, they ended segregation. Civil rights have allowed women and minorities to vote. The list is long and you don't need me to recite it to you. But no one wants to be on the wrong side of things like this. But even the civil rights platform can be abused and misused. And I feel like that's being done here. I feel like this bill went through, this 933 bill went through on the heels of the Me Too movement. Nobody in those hearings wanted to seem like they were speaking out against victims of Me Too. I mean, the timing of it was almost a guarantee that it was going to come through. But none of us speaking out against Blake are speaking out against real victims. One thing I see among other creators in comments under my videos, in comments on other creators' videos, in Instagram Reels, which I've been watching so many of those because I don't have TikTok, is a theme that I feel like I've heard just about everybody say, is that most of us are real victims who've been through real harm. Things Blake couldn't imagine. Someday I'll tell my own stories, but today is not that day. But we're angry. We're angry at the mockery. We're angry at the misuse of these resources that are there to help real victims. We're angry that every one false accusation creates thousands of real victims who will not be believed, who will not be taken seriously, who will not get the help and support that they need. We're so very angry as her husband jokes about the experience and laughs about Justin's innocence. Did you all see Elsie's video about Ryan and Sean laughing about Nice Pool?
So I'm going to play it again, and we're going to hear it again, what they call Justin, because I want to make sure it's really in there.
This is an example Ryan talks about making me laugh on set. This was one where it really got me. Ryan really committed to the absurdity and the sweet, innocent, oblivious idiocy of Nice Pool.
Okay.
So much of this was kind of made up on the day, too.
That's enough. I think we can all get it now. The man who you claim was sexually harassing your wife, whom you went out of your way to create a character for, you did not describe him in Deadpool. You did not make him a predatory character. You did not make him a harasser of Lady Pool. You did not make him a philandering, sleazy man. You made him an innocent, oblivious, what do you want to call it? Whatever word you want to call man. Not a predator, not a harasser. And then you laughed about it. And then
Shout out to Elsie, who calls out every single detail of this mess. But this is why we're angry, because they're over there laughing, and every day of our lives, we're tending wounds that we're still trying to process. Some days better than others, and Blake is whining about someone saying her self-tan smells good. By God, we're angry. And now they've lassoed in these organizations with Ezra sitting right on top. And the problem with that is this. Amicus briefs, filed by more experienced lawyers supporting petitioners, experienced a win rate about 8% higher than the benchmark rate. And amicus briefs, filed by more experienced lawyers supporting respondents, experienced a win rate nearly 10% lower than the benchmark rate. They are capable of changing the outcome of a litigation. Now, if they come in here with these factual allegations which don't belong in these briefs, these arguments these ladies made, all these claims they made, carrying the weight of organizations that no one dares speak out against right now, how much weight's that going to carry in swaying a court? And then we talked about evidence could be obtained through discovery if the judge allows it, but an amicus brief can focus the court's attention on the relevant piece of evidence and amplify its effect. The language that's used, as it is in this case, inflammatory, accusatory, can also influence the court. It can dispose the court against the defendants. And it already seems like Judge Liman is against defendant's attorney. And the judge is the one sitting there. He doesn't determine the verdict, but he has tremendous power because throughout the trial, he makes important decisions and he makes them in the presence of the jury. And if you think the jury is not picking up on that, you're mistaken. I watched a case in South Carolina that made me so mad. I did a week's worth of research, followed up on one of the attorneys and the things that they did, and I'm so angry by the outcome of that trial that I haven't been able to even speak on it yet. But I watched petitioner's attorney allude to something that the court had already determined was off limits to speak about, and she brought it up in such a way as to prejudice her client that it's unfathomable that she got away with it. And when the state objected and the court ruled in their favor, but didn't address the jury about why, and that case was lost, and it was so unfair because it was a murder case, an excruciating kind of slow motion murder of a man who set his wife on fire. But the judge's preferential treatment, especially from that, was so harmful that that jury forgot about the fact that this woman suffered horribly. So yeah, tremendous power. As it says, amicus participation goes well beyond mere policy argument and often involves active participation in the development of the trial court record. Thus, the power of amicus curiae cannot be understated. Now, Bryan Freedman has done what he can at this point. That's all he can do. He got 3 pages that he submitted within 2 days to try to stop this. But the kind of extreme language that was used, you can't take that back. So in addition to that, you can move to strike the allegations that were made. And if the court overrules your objections, you could seek discovery from the amicus. But again, these are not rules in the district court. These are available to people who deal with amicus briefs in appellate court and Supreme Court. This is all exclusively up to Judge Liman. And if he doesn't rule fairly, I hope Freedman files a writ and goes above to get this straightened. Because if this doesn't get straightened and the trial moves on, it's going to be a disaster. So they mention again this about one argument that Freedman does have on his side is this timeliness. That's usually the best objection to overruling an amicus being submitted. And of course, the appropriate courts, in this court, no 7-day rule, no deadline. The one thing is, though, one of the first moves the judge made was to set up his scheduling order. Hopefully, the prospect of destroying his scheduling order is enough to make him reject it. especially since they're wanting to be considered for the motion to dismiss decision. This is our best hope, that he doesn't want to delay this decision, and if he accepts these briefs, it could lead to a delay. Now onto this last topic we're going to consider for this episode, because this is ending up being much longer than I had intended. I have to divide it. So the last topic of this episode is excessive interest. So you can have a lack of special interest, or you can have excessive interest. We're not going to talk about a lack of special interest because I don't think we're lacking that in this case. But in my opinion, we do have a situation of excessive interest. So an amicus curiae's interest in the litigation can be so excessive as to result in denial of amicus status. This commonly occurs when an organization appears as highly partisan merely as an advocate for one party. There's no mistaking that in this case. Now it cites Lee versus Engel. The U.S. Secretary of Labor filed a brief that in every respect supported plaintiffs' legal theories and their construction of the facts, many of them disputed by defendants. That's important because we have exactly that. So the court concluded that the brief was not a memorandum amicus curiae, but was a memorandum amicus petitor, one offered as a friend of the plaintiffs. Finding such partisanship improper, the district court denied the motion to file an amicus brief. So this is good because we don't have rules about amicus briefs, but this decision was made in a district court. This can be used by Freedman to argue this case. And this is what that district court, which happened to be in New Jersey, how they explained the standard. They said where a petitioner's attitude toward the litigation is patently partisan, he should not be allowed to appear as amicus curiae. Where an amicus represents interests which will be ultimately and directly affected by the court's ruling on the substantive matter before it, the amicus's interest may be excessive. And it mentions one court berated an organization for failing to remain an objective, neutral, dispassionate friend of the court, and instead arguing that the court violated the fundamental constitutional rights of the defendant. This was United States versus Gotti. Yes, that Gotti. This was a fun little walk through the mob with Gambinos and all the good stuff. But the point was, I'm just going to read directly from that decision. Rather than seeking to come as a friend of the court and provide the court with an objective, dispassionate, neutral discussion of the issues, it is apparent that the NYCLU has come as an advocate for one side, having only the facts of one side at the time. In doing so, it does the court, itself, and fundamental notions of fairness a disservice. Chief Judge Aldrich cautioned in Strasser v. Dorley that it may be thought particularly questionable for the court to accept an amicus when it appears that the parties are well represented and that their counsel does not need supplemental assistance, and where the joint consent of the parties to the submission by the amicus is lacking. That observation is precisely applicable here. For the foregoing reasons, the court declined to issue its order to show cause and denies the NYCLU leave to file an amicus brief. So ordered. So we have a couple of cases that could be used as a standard since there's no law. Now, keeping this in mind, looking at this letter from these organizations that we already saw that Ezra sits on the board of one, which is insane, this completely feels like a chance for Blake to fit in one more motion to dismiss, cloaked in women's advocacy. Now, all of my research is not going to fit in this episode, as I said, so we're going to focus more on this Bill 933, which is 47.1. That was its name before it was passed. But for now, we're skipping it, and we're just going to read this paragraph. This action is the first test of 933, and survivors are watching. If the law does not protect a powerful and resourced person such as Miss Lively, then survivors without power or resources, the vast majority, will not risk speaking out about sexual assault or harassment at all. The Me Too movement taught us the result of that silence, systemic and unchecked abuse at great personal and societal cost. If this isn't excessive interest, what is? They're pinning this entire movement, their entire journey of getting this bill passed, on Blake's case. The manipulation is palpable. Survivors are watching? Survivors, yeah, we're watching. And we're disgusted. We don't look at Blake as winning for us or speaking for us. She's not in need of anything. She has everything. to help her get through this. This wasn't passed for people like her. You know what? Take all of this and go over to the Smokey Robinson case. Those victims were housekeepers. They're poor. Now, I don't know. I'm not saying Smokey Robinson is guilty. We don't know the facts of that case. But what I'm saying is, these are low paid. They're minorities. I believe all of them are Hispanic. In a way different situation than Blake was. Blake ruled that movie set. Everybody knows that. These are lowly house cleaners who needed their jobs. These are exactly what this bill was passed for. Go there. Make that your case. They probably don't have money for litigation. Take this to them. If the law doesn't protect Blake, the vast majority will not risk speaking out. Are you guys disgusted by this manipulation? I'm so disgusted. And I hope Judge Liman sees this for exactly what it is. It's as if they're telling him that if he doesn't rule in Blake's favor, it will be his fault that the vast majority of victims won't dare speak out. This is absolutely disgusting to me, and I hope it disgusts him too. They're acting like not finding in Blake's favor is going to ruin this, but Blake lying is what's ruining it. She's the one making women not be believed. These women in the other case, because they want one that's a big, well-known case, very public. These women say that they were actually assaulted multiple times over the course of years. That's the case this was made for. Blake wasn't powerless. She took the movie. It's her cut out there. It's her music choices on there. She got $600,000 to wear hers and her husband's and her friends' ugly clothes on that set. The power imbalance was the complete opposite. Don't put this on Judge Liman. Don't shame him with Me Too. But as I said, there's still a whole lot more information on this topic. But because this is already so long, I'm going to have to cut it into segments, like I said. So keep on the lookout for part 2, which is coming soon. Till then, this is Cassidy O'Connell saying stay well and stay tuned. Okay, let me test this. Can you guys hear me? Hello? Okay, let me test this. There we go. There we go. It's on now. Okay, guys. Thanks. My mic never wants to switch back on after I've shown a video. I don't know why. So I wanted to talk about 2 things. I've put them both in my on my community tab. One is just a little one, but it made me a little bit excited. It's that the New York Times has just added another attorney. And that makes me think that they're getting nervous that they might not be dismissed from this case after all. So during this time, we only get to see little things when they become big things, when they have to come before the judge and they have to file something. But behind all of this is a lot of discussions. So it makes me wonder what sort of things have been uncovered in discovery, what sort of conversations have been had, and if there's some reason that the New York Times thinks that they might in fact not get dismissed, which if you followed me through this whole thing, it would be, you know that that's my dream. You know that that's what I want, for them to be held accountable for their part in this, because I feel like they showed malice in what they did, but even if that can't be proven, at least reckless disregard, But anyway, so I'm hopeful that, and at least it shows they're getting a little bit nervous and that they know they're not just guaranteed a get out of jail free card from all of this. So that was exciting to see. But the second thing is that the judge did rule. And it sounds bad because you see the word denying first, but it's actually not bad. Do I think they'll be held accountable? I hope they'll be held accountable. But it's really, really super hard to hold the press accountable for things that they print. So I think a lot of it will come down to this sham lawsuit, and if they played any part in that or had any awareness of that. There's a whole, I mean, I can only speculate, but I've always said, because they said that they read thousands of pages of emails, that they printed beyond what they're privileged to print. If it's a judicial proceeding or a document in a judicial proceeding, they're protected. But the minute they talked about reading these thousands of pages, those weren't part of any legal proceeding. So, yeah, in New York, it's the hardest state to get a judgment. But there was one against Rolling Stone. So hopefully, not in New York, but still a member, press being held accountable for what they said. So this one, sorry, I'm operating on very little sleep. I was up till like 6 o'clock in the morning working on this. But so the motion to compel was denied, but that's not bad because she withdrew it. So of course it would be denied. There's no reason for this motion to compel anymore once she withdraws. So it's not like he went against Team Justin again and ruled against them. It's not like that at all. It's because she withdrew it. But the really good part, let me try to read this. I just grabbed this right off of Pacer, the little description for this document. So let me see the part I want to say. So as he says, it's denied based on plaintiff's representation that the relevant claims will be withdrawn. So it's not a bad thing. Lively's requests that because the parties have agreed to dismiss Miss Lively's 10th and 11th causes of action, the court exercises its inherent authority and authority under Rule 15 to dismiss them without prejudice is denied. So that's the really good part. Without prejudice to renewal. The parties shall stipulate to whether the dismissal is with or without prejudice, or Lively shall renew her request by formal motion. So Blake was wanting, and this was going to be what was in my live today, but some other stuff came out, and I had a feeling like we'd get some decisions today. So that's why I went ahead and postponed that live, and I'll probably do that tomorrow, depending on how things develop. But she wanted it dismissed without prejudice so that she could bring it up again. She still wanted to keep it in her pocket. And this ruling would keep that from happening. Now, it's probably not the end of it. There probably will be more back and forth. But it does give us a little bit of a clue about how Judge Liman is leaning in this thing. And I was saying it in comments, but I want to repeat it. At first, I was so impatient. I'm like, why hasn't he ruled on those motions to dismiss yet? But I think because normally it's like stuff like this, like he rules really fast on these kinds of things. But he's taken his time with the other. And I think it's actually wisdom on his part. He's getting a chance to see these people for who they are and what they're going to do. And had he ruled on things like the motion to dismiss a while back, he would have been ruling without enough information, I think. So now I look at it, I'm really glad that he's waited all this time because a lot of stuff has come out in that time. So even the fact that he never granted during that last hearing we had, and I can't remember the date, but it was a while ago, he said at that time that he was leaning towards granting the New York Times motion to dismiss, but he still hasn't done that. So I think he's just a patient man, and I think he just wants to see like the whole story before he jumps and makes rulings, because judges are also keeping in mind, like down the road, any kind of appeal. So they try to avoid making bad decisions that would be appealed or a cause for appeal later. So I've got a new appreciation for his patience. And, it's not that he's ignoring the case or putting it off, because we can see in times like this, he brings back a ruling like in less than 24 hours. So, I mean, in this time, we've seen the sham lawsuit and sham subpoena. We've seen Blake's team refuse to supply that subpoena to Team Justin. Now we've seen these shenanigans. So I think he's got a much better picture of who everyone is at this point. And so I don't mind at this point. I don't mind waiting longer for him to rule on these big things. And this ruling was promising. I was so afraid. I was like braced for the worst to see how he was going to react, because I can't help it. I was starting to feel like he was just unabashedly on Blake's side of everything. So yeah, I was happy to see this. And for these briefs, I don't know if my video was kind of long and kind of deep. It was like a week's worth of reading and rewriting and all that. But the whole point of it is that there just aren't rules on a district court level for him to decide. Like, he can't look it up and go, okay, this is the decision I should make. Those rules don't exist. They exist in appellate court. They exist in Supreme Court. The good thing is that I found in his background that when he first started, he clerked in both of those courts. So he should be really, really familiar with these briefs. But the point is, without that law, it lies squarely on him to decide what he's going to do. And that's why I liked those two cases, the one in Jersey and the one, not Michigan. I forgot what the other one was. But they were both on a district court level, and they both decided not to accept these briefs. So that's why I threw those in there, because it's given me hope that him seeing cases like that were denied on a district level, when you don't have a law to help you decide, that's what you use. You use other cases as kind of like a precedent. Well, based on this case, I'm going to rule this way. So hopefully he will come across in his research cases like those where in the district courts, they did choose not to accept those briefs. And so I'm really hoping, based on timing and on those other criteria, that he will not accept those briefs. But at the same time, there's all this pressure, because like I said, it's a women's rights issue. It's a civil rights issue. Nobody wants to be or appear to be on the wrong side of things like that. So yeah, but anyway, I'm hopeful after this ruling, and also extremely hopeful. My opinion about her not wanting to provide her medical records, personally, and this is just completely opinion, I think they don't exist. I don't think it's that she wants to keep them private. I think they don't exist. And in the live I was going to do today, I went through the criteria that she has to have to prove this kind of, it's a very severe thing, what she's claiming. And whenever you get to like very drastic, severe things, to prove them is also, it's quite a challenge. So I've gone through in California law and got those things prepared for you. And that's what my live is going to be about. So when faced with having to prove her claims, I think this is like the first crack of many. She's made all these claims, but when it comes to proving them, I think they're going to fall one by one like dominoes because she simply doesn't have the proof, I feel. Let me see what you guys are saying. Yes, Riley, she wanted to keep it in her pocket so she could go get a sketchy doctor to state she has been distressed, backdate some records so she can be like, see, it's true. You know what? I said that to my husband last night. That's exactly what I said. I really think that's what it was. Isn't that awful? And I think we all think like that. And you know why? She made us think like this because of things like her sham lawsuit. Okay, let's see. Okay, mildly, it's not just you, Cassidy. A lot of us have been concerned. I think anybody with half a brain that's really, really watching all this, can't help but be concerned. Marbella, I confirm, and I still don't trust him blindly. Yeah, I'm happy about this, but I wouldn't use the word trust yet. I agree. She has no records on any emotional stress. Thanks, July, baby. Yeah, that's what I think. Jacqueline says, I think that there's something or multiple things in her medical records she doesn't want released. That's a possibility too. And it's so hypocritical to me. We're talking about the woman who, how many people have they either doxed? And then after that doxing, we had people getting death threats and we had arson. She released Jed Wallace's private information, things that nobody knew about. She mentioned Justin's mental health. And I know that he did on his own terms talk about that in previous podcasts, but he didn't release it in this particular, in this lawsuit. So she had no right to be the one to first mention it. Jenny Rose Campbell says, I can't imagine she has any therapy because then she'd have a diagnosis of being pathological and narcissist. A lot of people say that. Wait, it's moving, so I clicked the wrong one. I always do that. The only emotional stress she has is from Ryan Reynolds, and that's why she's afraid. You know what, yours, Cinderella? I think so too. It's all, again, and I'm just talking personal opinions of things. I think Ryan got jealous. And I think he even didn't want her, because remember, she wasn't returning to the set. I think he had a lot to do with that. I think he saw texts between her and Justin, and Justin's texts weren't inappropriate, but hers were. And I think he got mad, and I think he got jealous, and I think he was like, you're not going back. And I think that 17-point list and then him coming around, I think had more to do with that than anything else. The world will get to know who the stress causer was, and we will all know it's Ryan Reynolds. Yes. Okay, and Riley, she also knows if she tries to turn around and blame it all on Ryan, that he'll turn right back around and burn every single bridge she might have. Yeah. Their relationship is interesting, but I could see them turning on each other. I really could. Let's see. I'm going to go ahead and we've already been on for quite a while. So, oh, hey, Leanne. Good to see you here. Let's see. Bridget. Is it? Yeah, Bridget. First I read it, Bridget. If emotional distress is removed from her complaint, can Freedman still bring a therapist at trial as a witness? I'm going to say, honestly, I don't know. If any complaint related to emotional distress gets dropped, I would think not. But I'm going to answer you honestly and say I don't know at this point. Yeah, I don't even want to venture an opinion on that right now. Your Cinderella, because how come he was hanging out in her movies, fighting in her trailer like a little bee? Exactly. There's some stuff going on there. I don't think either of those two people are healthy, shall we say. Yeah. Rules for thee, not for me. You're right, July. They want to talk about Justin's being neurodivergent, but she doesn't want to talk about hers. And here's the thing. If you were truly emotionally distressed, you would want your records to be put there to prove it. It's not, now we have this attorney's eyes only. Remember, they put that stipulation on there? That would protect her from this stuff getting out. It also isn't going to be like all of her mental health records. The only bit that would be used is anything that would be important to this case. And that wouldn't come out until trial. So the fact that she's closing this off is kind of, it's suspicious. Eliza Little says she was trying to flirt and it fell flat with Baldoni. I think so. I love that one where she's talking about being flirty and yummy and, you know, what did she say? Something and then no teeth. And he responds with crying because his family just left and he's going to miss them. And it was just like, he didn't bite. He wasn't interested. And I don't know if you guys ever watch videos of him with his family. His wife is adorable. Not just physically. I mean, she's gorgeous, but her personality is just so appealing. She's funny. She's sweet. I mean, you just watch the videos of her and you're just dying laughing. And he can't stop laughing at her because she's so adorable and so cute and funny and so opposite of Blake. You know, Justin's the kind of guy, he could have had his choice of a lot of women. He chose what he loves, who he loves, and why he loves her. She couldn't be more opposite to Blake if she tried. I mean, it just like, why would he be attracted to something that's so opposite? You know what I'm saying? I'm not saying it because I'm so tired. I'm not saying it like how I mean to say it. But when he told Blake, I'm not attracted to you, I think he was being brutally honest. That's not, she's loud, she's pushy, she's obnoxious, she never shuts up, she's not funny. She's nothing like his wife. I think, honestly, that's not the kind of girl he was attracted to. Yeah, she has vibes. She's adorable. She's amazing. She's supportive. She's just so cute. Yeah, they're the real power couple here. And Blake is shallow. And here's the thing about neurodivergence. They read people so fast and so quickly. I mean, and so easily. Even if they don't exactly know why they pick up a certain vibe about somebody, that vibe is there. And it's like something in your whole body. Like if somebody's being dishonest, it's like a feeling in your whole body. Your whole body knows it. And you don't know why you know it, but you know it. And even like the way he started immediately when there was trouble, he had that camera rolling. He had himself mic'd up for that dance. His neurodivergence was serving him well. He knew he was in danger. He knew he was not safe. And he was, wasn't fooled by her. So, yeah, I saw this, July baby. I'm hearing she wants to still pursue emotional damage from the sexual harassment, but she will still need to provide the sane records. Makes no sense. Yeah, that's the thing. If she drops it in one area, but she still tries to use it in some of these others, I don't want to, guess at what's going to happen, but I'm excited to see what Justin's team will have to say about that, because I believe they will have something to say about that. Yes, she said Justin was the first man to ever make her feel safe. At least 3 people have used the word safe to explain Justin. Safe. Yes, and Isabella was one of them. When she sent him those texts after she filmed with him, thanking him for making her first filming experience so safe and comfortable. That said so much. And there's a long list of women who've made videos to support Justin, and they're women who've worked with him. When you come across a creep and somebody finally brings them to court like this, when you start digging in, you always find a long list of women coming forward and saying, this is my experience. This happened to me too. And even this ex-CIA guy can't find anything. The biggest thing, and I always say this, the biggest thing they've been able to pull up is someone calling him, saying he has toxic positivity. That's just ridiculous. They can't find any woman who's ever been made to feel uncomfortable by this man. So let's see. Yes, we pay attention to patterns and energy and a million little things that get processed. Eye movements, changes in breathing, all kinds of stuff. You don't even know it's happening. You just know you feel it. Let me see where. Yes. Wayfair, Sony, CRD, everyone tried to help investigate her claim and she denied it. Also, why didn't she go to SAG? Exactly. SAG, they're all set up for it. They have phone numbers, they have hotlines, they have websites. They're there to help you get an investigation going if something like this happens. They represent you. They're a union, and that's what unions do. And it's very odd that she never wanted it investigated. Yes, Ryan, Bridget, I agree. Ryan wants a stay-at-home mom. So by destroying Blake's career, he'll have it. And by destroying Justin's career, he'll have revenge on him. So in the end, Ryan Reynolds caused all of this and he'll be the winner. I have said that from the beginning, that this is Ryan. I mean, it's her too. But I think if you go all the way down to the root, I think it was Ryan. I think it all started with Ryan. I think we also have to shout out Jamie Heath. If you read his and Justin's texts, he's the one Justin goes to vibe check, and Jamie's amazing. I agree mildly. All right, let's see. Yes, Eliza, this has bothered me so bad. So sad how quickly the cast turned on him. I still can't bring myself to watch Sklanard on 1923, and I love that show. It makes me so mad. It really does. They bought the love bombing, and not that I'm officially medically diagnosing Blake with narcissism, but the narcissism as we talk about it, like we see someone, oh, what a narcissist, not as like an actual diagnosis, but narcissistic tendency people are very good at love bombing. And that's what she did. We saw her wrapped around Isabella all the time, putting her in her clothes, putting her in her jewelry. At one point, calling herself her mom. I'm like, this girl has a mom. You're not her mom. Get your hands off her. And she was flying them around to things like they weren't supposed to be there for that whole book thing. And she puts them in her jet, flies them around. Oh, how exciting. She's taken them to the Deadpool premiere. She's taken them out to eat in New York. This fancy, exciting life that they'd never experienced. And they thought she was amazing. And when someone that you like or trust starts telling you this sad story, you would be like, oh my goodness, that's so awful. Oh, hey, Nirvana. And I think that's what happened. And just hopefully with the passage of time, they've come to see what was really going on. Let's see, what else have I got here? Not that where I always so uncoordinated. Beginning to think the public should sue Blake Lively and Ryan Reynolds for severe emotional trauma they're causing. Somebody said that earlier when I was showing the video. They said about being traumatized by Ryan Reynolds' voice, and they need to file an amicus brief, and I thought that was hilarious. All right. Yes, telling her that Taylor Swift cast her. I don't think it's true either. I know if I say something too nice about Taylor, I get attacked by the people who hate Taylor, and they're like, oh, she's involved, oh, she's this. I don't think she was. I think her life is so much bigger than Blake Lively's movie. You know, especially then, she was on her Eras tour. That was a grueling tour. It wasn't just, oh, show up on this day and perform. Every week was a different venue. Her show, I don't know if you guys saw it, but it's got stages that come up, stages that, floors that drop out. She dives into the floor like it's water at some point, and she gets scooted across on a scooter. She had a million clothing changes. Those kinds of things, they're not safe to just go out there and do on a different stage. So she would have to go in advance, practice on that stage. Every week was a different show. She would have a change up of certain parts of the concert. They would be different every single concert. So she didn't just get to show up then. She had to come like days in advance and practice and prepare all of this stuff. She was in a new relationship with the football player who's also traveling. When it's game season, he's got a game in a different city every week too. So she had enough on her plate. I just can't see that she cared that much. She even said she didn't see the movie for weeks after it premiered. And she never shouted it out, even though it had her song in it. Like, there was nothing. So I believe her that she didn't have any role in this other than like talking to her friend from time to time when her friend reached out to her. That's my opinion. And also the fact that she was willing to participate and give information to Justin's team. That says so much. So yeah, I think she was just the name that Blake dropped. All right. Oh, thank you, Kiki. I don't think I can read that right now, though. I think I get too emotional. So let's see. Oh my goodness, how amazing. Jacqueline, I went to her Eras tour in Dublin. It was amazing. Pity about her choice of friend. Blake Lively used Taylor's name for her own agenda. I love Ireland so, so much. My mom's father is from, well, not him, but his ancestors are from Galway. So I went there right before COVID, right? Like the month before lockdown. I went there and it was so amazing. It was February though. It was so cold, but I loved it. I absolutely loved it. And I want to get back. I want to get back in the summertime, but I love Ireland. It is truly one of the most beautiful, like the land of it is so beautiful. One of the and the people were so friendly. I got lost in Dublin. I was headed to the wrong bus stop, and I asked, there was a woman walking by, and she asked me, do you need help? Because I was looking and like on my phone and like trying to sort out where I was. And I told her what bus I was trying to get. And she's like, oh, it's not this one. It's another one. And she started to give me directions. And then she's like, I'll show you. And she walked me for blocks and blocks, got me to the bus stop. And then it wasn't like the way she was going. Like after she left me there, she headed back in the other direction where we came from. So she walked so far out of her way just to walk me to the right bus stop. I mean, such friendly people. All right. Yes, come back on our side of the world. You know what? I would live in Europe if I could take my whole family with me. I love Europe so much. I think it's so beautiful. And, just a lot of things like medical care, is so much better. You don't have all the trouble that we have with insurance and, big pharmacy, all the things. I love Europe. Yeah, I feel bad for the kids, Bridget. I agree. It's going to be difficult for Taylor Swift because she's the godmother of those kids. Yeah, she put them in songs, or their names are in some of her songs. So, and I think she was friends with Ryan for longer than she was friends with Blake even. Okay. Yep. That's the Irish for you. Truly. Very, very sweet people. Yeah, I think she might be done with Blake. I think Taylor's probably a scorched earth type person. That bridge is burned. Maybe when the kids are grown, she'll reach out to them. Who knows? But all right, guys, I'm gonna call it a day. I've got the other half of the amicus briefs, and that's gonna deal with the path of 933 becoming 47.1. And that's a lot of research and a lot of writing. And then I also have the live I was going to do today. I'll be watching the updates. I think there's going to be some more updates throughout the day and get that ready probably for tomorrow. But thank you guys so much for joining, and thanks for chatting with me after. And hopefully you can understand a little bit more about these amicus briefs, why it's so tricky, because there just aren't rules or laws for it in this district court level. But what the risks are with it, and what some maybe hopeful things about it. But yeah, I'll be working on those other two. Till then, this is Cassidy O'Connell saying stay well and stay tuned.